Hi, my name is Grace Chang and I'm an attorney here at Song & Associates, and this video is going to be about work visas for those who are looking to start their own business. So if you're an entrepreneur looking to do a startup, this is for you. We get consultations like this all the time from clients who are thinking about starting a business, or maybe you started a business during your OPT period if you're here as a student, and you're like, how can I use this business to now sponsor me for a work visa? So one option is the E2 visa. The E2 visa, as many of you guys know, is for treaty investors, and that means that you need to be a national of a treaty country. If you are, then lucky you. You can apply for the E2, and there's also the E1. And for the E2 or the E1, you have to show that the business is owned by a national of a treaty country, and you have to be coming to either be a manager or an essential employee. If you're going to be coming here for E2, you have to show that your investment in the business is substantial. That means it has to be proportionate to the business, and that the business will not be marginal, which means you're going to be making more income than just for your livelihood. So I think that is the hardest thing for a lot of startups, is if you don't have any income yet, a lot of times in the beginning, there are a lot more costs than there are income, right? Revenue. But you can still overcome that if you're able to show, hey, these are our financial projections, these are the investments we're making, and based on the market studies that we've done, it shows that we're going to be profitable within the next 5 years. So that's definitely an option. If you're doing E1 for trading, you have to show that there is substantial trade between the treaty country and the US or another country, right? As long as there's continuous voluminous trade. And again, trade doesn't have to be just products, right? I mean, I've done a lot of E1 cases for products that are being traded between two countries, but you can also trade services. So that's something to look into if you're doing a consulting company, and if there is a lot of trade between the two countries of two different types of services, that could qualify technically as an E1 trading company. Another option that you might want to consider is the O1. The O1 is for extraordinary ability, yes, and you could do it in the arts, or O1A, which is for sciences, for business, for all different case types. If you're creating a company and you can show that you have extraordinary ability in it, that can be shown by meeting 3 out of 6 criteria for the O1B or 3 out of 8 criteria for O1A. You can also use that company to either be your employer or to be the employer agent, which means you can use that company to be an agent for third-party employers, which is a great benefit because it gives you that flexibility, or just simply be an agent. And so I've seen a lot of entrepreneurs open their own business. For artists, I've seen graphic designers who've worked for big companies now open their own shop, and they use the L1 to show that they're going to be working in their field of extraordinary ability as the owner. Another option is the H1B. Now, for H1B, of course, there is the obvious con of having to apply for the lottery. But if you're already in H1B status, let's say you worked the past 3 years with a company, you've gained the experience, and you're like, I think I can do this on my own, and you want to create your own company, you can transfer your H1B to the company that you've created, as long as you can still show that you're going to be working in your specialty occupation, as long as you can show that this company will have the ability to pay your prevailing wage, as long as you can meet all the other requirements for the H1B, that is a possibility. And that might be a good option for those who are also laid off, right? You have 60-day grace period. That's a short amount of time, but if you're able to create a business and do a really solid business plan, you can file for change of employer to that company. You also have to show there's a bona fide employer-employee relationship, so that's also really important. Now, because of the final rule that was issued last year, it also means that you can, the standard is lower, right? So you don't have to show that you already have a lot of people that are hired by this company. You can do a brand new startup where you're the only employee. As long as you can show that the majority of your work is going to be in the specialty occupation, you can get an H1B for 18 months. If you have a startup that's already well established, then you can go ahead and try for that 3-year, enter into the lottery, if you're not in H1B yet, and see if you'll get selected. Another option for entrepreneurs is the L1, and this is mainly for my overseas clients who are already working in a company that they've created in their home country. They're the CEO, the president, the VP, and now they want to create a U.S. subsidiary or a U.S. sister company. For those clients, it's very straightforward to apply for an L1A new office. That only requires that you set up the office, that you have a hiring plan. You might have 1 or 2 people on payroll already, and you want to show that there is a qualifying relationship. So that means either there's a parent subsidiary relationship between the 2 companies, or you could do an affiliate company. So you can have an individual owner of the foreign company also be the individual owner of the U.S. company, and now there's an affiliate relationship between the 2. That also works. The only requirement is that the individual must have worked for the foreign company for at least 1 year and will be coming to work either in a managerial or executive position for the U.S. company. So as long as you can show that, you will get a visa valid for 12 months. And then after 12 months, you have to show now the company is well established and will now be able to sustain, right, a managerial or executive position. And then you can apply for a 2-year extension on that L1 up to 7 years. There's also something that we've seen called the entrepreneur parole. That was a program that was created under the Obama administration, and it allows entrepreneurs to get paroled into the U.S. to make a significant investment or to create a business, right, to invest in the economy. And there are like strict documents that you have to show at the border. But the advantage of that is that you don't have to apply to USCIS first or at the consulate. You can enter through CBP by proving that you're an investor or you're an entrepreneur and you need to come into the US for that specific purpose. And again, when you're paroled in, it's not, a non-immigrant status that you can change into, but it's something that allows you to come in for that specific purpose for a specific period of time, and then you would have to leave. So there is the option of an entrepreneur parole. I would definitely consult with an immigration attorney to make sure if that's a valid option for you, and backup plans if you're not able to get paroled and there might be additional fees at this time. Thank you for watching. Hope this was helpful. If you have any questions, feel free to reach out. We're always here to help.